Hello, you are listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira.
Hi, I'm Tammy, and today I am going to talk about child custody is a mental game. Now, I know you guys are probably like me. You're probably automatically waiting for that. Hi, I'm Thomas to chime in, and if you aren't aware, Thomas passed away unexpectedly about 6 weeks ago. And if you want the details on that, you can go back to the May 9th episode that I recorded and get all that information. I today want to talk about the mental game of the law and the court system. And here's the thing. Every attorney that I know that I have spoken to, about practicing law and the stress of it, and family law in particular. I think any area of law is stressful. Family law has so much emotion in it on an ongoing basis that it's difficult. I can imagine that criminal, when you have people's lives in your hand and all that kind of thing is tough too. But I have found that over and over, the one thing that attorneys are afraid of that they almost never, ever say, I never hear anyone actually say this to me, but I've confirmed it with multiple attorneys over the years. And the number one thing that they're afraid of is being sued of malpractice. Now, I would assume, that most of us can relate to that. I know that I worked in the medical field for many years, and I know that's something that doctors worry about as well. And so attorneys really do worry about this. And, so it's kind of a double-edged sword. It's not just the fact that that could take them down, their career down, their livelihood, their family's well-being, and all that kind of thing. But also, I think that a lot of attorneys, especially those that practice in family law, do care about families and children, and they want to do the best job they can, and they want to do the right thing. Now, some of them are in it for money. I'm not going to say that there aren't people like that. There are people like that in every walk of life. But I think that what the point I want to make about this is that this becomes mental warfare for them. Okay, it's kind of like both of my boys played basketball in high school. And I know that for both of them, especially my older one, I think was very kind of mentally into the game and mentally into, faking his opponents out or trying to intimidate them in some way or, trying to, fake or bluff certain moves and that kind of thing. And so that type of mental jockeying comes into the courtroom when you have attorneys. And so I think that's something that we don't really step back and think about a lot, but attorneys are usually highly driven. They're typically, a type A type personality where they're really pushing and they're really driven. I think that Thomas was unusual in that way, in that he's kind of more of a type B. He's more easygoing in some ways. And that's one of the reasons that he struggled with the practice of law a lot in the emotional realm of it, because he really just wasn't about trying to, play mental mind games with the other side. And I think a lot of attorneys do that. And so, but let's talk about, so within the context of when you have an attorney and they are going to court, and bear with me if you don't have an attorney or can't afford an attorney, because we're going to walk down that path of what all this looks like. But if you do have an attorney and they're getting ready, especially for something big like a trial, then they have certain weapons, right? Certain tools in their tool chest that they can use. Now, what's their number one tool? Their number one tool is the law, right? That's what they're trained in. That's what they went to school for. That's what they've studied. And then when they get in and they're practicing in a specific area like family law, as they're doing that practice year in and year out, their knowledge and their wisdom and their experience is increasing over that period of time. So they get to know that particular area of law very, very well. Now, if you ask a family law attorney about a criminal law or a law related to probate or some other area of law, they're not going to know the answer to those questions off the top of their head like they will normally know the answer to a family law question like that. And so, because they're not specialized in that other area. And so do they know how to do the research and how to find the answer and how to dig for it and all that kind of thing? Sure. They have learned how to find those answers. And that's part of what they were trained in law school, is how to find those answers. But knowing the law off the top of their head comes from that day in and day out practice of it. It's kind of like when a doctor goes to school to be a doctor, and then they spend extra time specializing if they're going to be, say, a heart surgeon, right? And then they spend years being specialized in heart surgery training, and then they eventually start on their own. And then as they go, they learn more and more about heart surgery. But if you want them to take out your gallbladder, probably not something they're really accustomed to doing. Not that heart surgery isn't more complicated than taking out a gallbladder. I would assume it probably is. It's just that they don't have experience in that area. And so it's the same kind of thing with an attorney, is they get very versed in the area of law that they're practicing in. And so that's one of the reasons that I tend to favor somebody that specializes solely in family law, in divorce and child custody. Some people practice, 4 or 5 different areas of law. And I think that's more common in smaller, more rural areas. I think it's harder to find somebody that's specialized like that. But when you're in a large, metropolitan area, then you shouldn't have any problem finding someone that's very specialized in that, because knowing that law and knowing it off the top of their head in your state is going to be a huge advantage in the case. Okay. What's their second weapon? I think the first one of it being the law, that's kind of a no-brainer. You probably expect me to say that, right? The second weapon is more of a mental warfare type of weapon. And part of an attorney's job is putting the other side at risk. So why is that? Because the more risk that they can create for the opposing party, the more leverage they have to get the case settled or to get the other side to give in to their terms and conditions or whatever it is. So it's sort of like, if you can think of it like I said, relating back to basketball or relating to a poker game where you're holding this hand, and the more that you can make the other side think you have this fantastic hand, the more likely they are to fold, right? And so these are the types of things that are going through your attorney's mind when they're when they're working on the legal aspect of your case, okay? The third weapon that I think that becomes very important for the attorney is preparation. So when we talk about getting ready for court, Thomas used to say, for a trial, for every hour of trial I have, I need at least an hour of time to sit and prep. Okay, because they have to work up their direct examination, their cross-examination. They got to know all the different facts of the case. Thomas used to sit down and make a whole new list of notes of dates, date of marriage, date of separation, birth dates of the kids, full names, have everything kind of in front of him and go through it ahead of time. And a lot of that stuff, even if a paralegal could do it or type it out or do whatever, it doesn't get it embedded into the attorney's mind in preparation for this trial or this motion that they're going to do, right? They've got to have those facts embedded in their brain on your case. And so that's part of what they get really focused on preparing for. And that's after we've already done all the paperwork, filed everything, and done all of that. This is just the attorney sitting down and mentally preparing and thinking through, where are my good areas where I have strong legal argument on the law? Where are the areas that I can potentially put the other person at risk and poke holes in their credibility and in their testimony? And then, as I'm preparing, I'm thinking through those things and I'm figuring out what all those different pieces are, right? And so sometimes I think we can get a bill from the attorney and be like, holy cow, how much, how was it this many hours of time just to do this one little thing? But honestly, so much, of the mental preparation side of it requires that attorney to sit down in the quiet and really pour over your case and get your life essentially embedded in their brain enough to where they can talk about it as if it were their own life, as if it were second nature. And that doesn't happen, instantaneously. They've got to take the time in the process to do that. And, things always take more time than what we think they're going to. I had a client a couple of weeks ago who went in to do her own emergency motion. She had an attorney. She didn't have one in this little window. She was working on getting a new one, but something happened and she needed to file an emergency motion. And, I remember her calling me and asking a couple questions on documents and, what does this blank mean? And, what are they asking me for? And a couple different questions like that. And she accomplished the goal. She got it filed and she actually got the ex parte order, which I would say 80 to 90% of ex parte motions are denied. So just the fact that she was able to get that was like, yay, kudos for her because she accomplished what she was trying to accomplish. But the irony of it is she came back and she said, that took me almost 4 to 6 hours, I think she said, by the time she put all the time into it to, prepare the documents and do all the stuff. And obviously she's educating herself as she's going along. So, somebody that does it all the time would know exactly what the forms were and where to find them and how to fill them out and all that kind of thing. But it's extremely tedious and it does take a lot of time. And so that's where a lot of the paralegal and the clerical type efforts go into, is just trying to get those documents, done and finalized and into the court. And so your attorney is going to use all of these weapons. Once we have everything filed and all that in, then they're going to sit down and go over everything. And let's not forget, they had to go over everything in the first instance to decide what facts go into your declaration. What exhibits are we going to present? Which things line up well with the legal arguments? Which things put the other side at risk? Which things don't have as much value? And you only have so much time. So they really have to analyze it and figure out, what are my top 3, maybe 4 points that I can really drive home that are going to give me the best leverage. Okay. So a lot of times I have clients come back and say, I'm really frustrated. I feel like my attorney didn't say what I wanted them to say, or there was this particular thing, or I wanted them to point out that I didn't do A, B, C, or D. What you guys have to keep in mind is that's emotional for you, right? That's an emotional need you have to be validated, to be heard, and all of those things. And just because you have an emotional need around an issue doesn't mean it's the best argument in your court case. That's what you're relying on your attorney for, because we're relying on their knowledge of the law. We're relying on their experience at putting the other side at risk. We're relying on their ability to prepare and analyze your case. Okay. So you might not always think that it was the best thing, but if you have an attorney that you trust, you have to trust that they know what they're doing. Now, let's talk about, and again, I'm going to bring this back home if you don't have an attorney, so stick with me, okay? But let's talk about now, what are your weapons in the battle, okay? So we've analyzed the attorney's approach, and we know what their weapons are, okay? They're really in the mental warfare, the law, the preparedness, all those kinds of things. But for you, your weapons are as follows. In my experience, these are the top 3. I'm going to give you the top 3 things that I think are a client's biggest weapons based on my 15 years of working alongside Thomas in this day in, day out, exclusively in family law. Okay. Your communication with the other side is almost always your number one weapon. And the reason is because if you can do it right, if you can do it well, you can boost your credibility with the court. You can show the court that you're trying to be cooperative. You can show the court that you're trying to be reasonable. You can show the court that your ex is difficult. You can often, through your own behavior, create situations where your ex shows their true colors and becomes difficult or becomes combative or any of those things. And that communication can be gold for your case, whether you're representing yourself or if you have an attorney. If you have an attorney and you can handle your communication well, your attorney's going to love you, because honestly, most of the time, your attorney's ability to succeed or fail in court comes down to how well you use your 3 weapons. Okay. The attorney's only as good as what you give them. Okay. They can only analyze and prepare and do all those things based on the information you're giving them to work with. So if you're going into your communication and you're handling that poorly and you guys are going back and forth, or there's a lot of argument with your ex, or there's a lot of conflict, or you're documenting your case in your communication, you're doing it wrong. And then you hand that to your attorney and they're like, well, I can't use this. This isn't helpful. And so instead of being able to give them some leverage, a bullet in their gun, so to speak, for lack of a better metaphor, you've left them flat because the communication doesn't make you look great either. And I find this is highly underrated because it so impacts your credibility. And so the credibility doesn't just affect what you're saying in that moment. It affects the validity that the court gives to every argument that you're making. Because if I'm behaving poorly in that communication and the court thinks, wow, this person's really not handling this well, and then I'm claiming all these other things that are problems, the court's like, well, they're not using great judgment in their communication. How do I know that all these other complaints they have aren't just misjudgments as well? And so that communication in and of itself won't necessarily get you, sort of a gold star or a red mark in and of itself from the court, but it does highly impact your credibility, and it does show your desire to try to cooperate and communicate with your co-parent, even if they're being unreasonable. Okay. What is the second thing? The second weapon that you have is your own behavior. And again, this is a place that when emotions get high, and let's face it, especially at the initial breakup, for all of us, emotions are usually high. And so when your emotions are high, or you have an ex that's able to push you into anxiety, into fear, into stress, guess what that does? Makes you reactive. Guess what happens when you're reactive? You don't behave well, or you don't behave the way the court would want you to. Okay, so you have situations that come up, those hiccups, right? Somebody's late for a pickup or drop off. Somebody comes over to the other one's house and they're drunk, and do you call the police or do you not? Somebody shows up at the pickup with their new mate who is, vitriolic and attacking the other parent. All kinds of things like this that pop up in the normal day-to-day stuff. That's not like a situation that you can go, oh, let me just freeze frame this situation until my lawyer's in at 9:00 tomorrow morning so that I can then call and ask what to do. Right? That's what we'd all love to be able to do so we could make the right decision every time. But you don't have that option most of the time. And so a lot of times people will make decisions in that moment that are intuitive to us as what we think is reasonable as a human being. But I find a lot of times in those decisions, the court goes, not really the best decision. Now, what does that do? Hurts your credibility. We're back to the same problem. So if you're behaving poorly as new situations come up like this, guess what? You're handing your attorney situations where you've already kind of dug the hole and they can't magically just pull you out of it after you behave poorly. If you want your attorney to win your case, the best way for you to help them is to communicate well and to behave well. And even if you don't have an attorney, you need to do those things so that when you go into court and you're representing yourself, you can show the court that you're trying to do the best that you can and that you're taking responsibility for your part in the situation. And that builds your credibility in front of the judge. When you're in there and you argue and you're argumentative and the court says, well, you didn't do this. And they say, well, but he didn't do this and she didn't do that and blah, 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 blah. And the court's like, I had a client a few weeks ago where I observed him in court. And after court, I said to her, you're arguing with the judge. You're self-represented and you're arguing with the judge. Like, just answer the question. If the question is what color was the ice cream, you don't start with, well, see, it was 7 p.m. and we went down to the grocery store and they were out of vanilla. And so we got no, what color was the ice cream? That's the only thing they're asking. And clients are guilty of this a lot because we want to give details. We want to justify why we did what we did. And we want to be heard. We want to be heard. This process is emotional and we want to be heard. But here's the thing. The courtroom is not the place for that. When you start trying to be heard in the courtroom, you blow up your credibility. And so if the court's question is, how many times has the other parent seen the child in the last 30 days? You don't say, well, see, 3 months ago, they were seeing them this much. And 2 months ago, we switched it and it was no, the question is, how many times in the last 30 days? 4 days, 6 days, 3 times for 2 hours apiece. Whatever it was specifically, just answer that question because the court is looking for something very specific when they're asking those kinds of questions. They're not looking for a whole background from you on what's been happening. And honestly, this issue right here that I'm talking about of giving too much detail in court and elaborating too much, which ladies, we're guilty of. I'm sorry to say, I'm right there with you and I'm a talker, as you all know. And so honestly, I get it. It's kind of preaching to the choir kind of thing because I already know. I get it. I'm a talker. I want to be heard, all of those things. But this is one of the number one things that causes judges to get frustrated with somebody. And a lot of times what will happen is you'll get cut off. They'll stop you. You won't be able to get in your whole life story of what happened. And people come back and they say, that judge was against me. That judge wouldn't listen to me. That judge wouldn't. Well, a lot of times, here's the problem. That judge has 15 cases on their calendar that they have to get through. And they're trying to ask you for specific information so that they can make decisions on this case, be done, and move on. They don't have time to spend 30, 60 minutes on every single case, letting everybody feel heard. Our justice system is just not equipped to handle that kind of volume of information from parties. Unfortunately, it's sad. It would be nice if they were, but they're not. Okay, so then what is our third weapon from a personal perspective? Our third weapon is educating ourselves about the law. Okay, you don't have to have gone to law school to be able to represent yourself in court. If you're in a situation where you can't afford an attorney and you have to represent yourself in court, then that's the situation you're in and that's just the reality of it. But what you can do is there's a law library. There are resources. A lot of the courts have online, self-help resources. If you're in a small rural area, the procedures might be a little different, but the laws are the same statewide. So a lot of times you can find online law libraries in different counties that will give you some of the same basic information. In California, one of my favorite online libraries is the Sacramento Law Library. I just think it's set up really well online. It has a lot of good resources. I use it frequently. I'm in San Diego. Procedures vary slightly county to county, but the law in the state is the same. So that's a great resource that I can tap that's available. And so you have to get online and explore and try to educate yourself about what the law is in your area, especially if you are going to represent yourself. If you have an attorney, that's obviously not as critical, but I think it's still helpful to understand what your attorney is up against and what they're trying to do. So even if you're in a situation where you do have that attorney and you do have somebody that's covering the law part of it, the more you understand the law and the more that you know what's going on, the better you can equip your attorney, because you're going to be able to go through the different pieces of evidence or communication or information that you have, and you're going to be able to share that with your attorney and know that it's relevant. Thomas used to say one of the things he hated most was when he had a client that sort of came in with a shoebox. It kind of dumped everything out of the shoebox onto his desk. That's obviously an extreme example that I think only actually happened one time. We had a client that was that disorganized, but doing that, it not only is overwhelming for the attorney, makes them feel like they have tons of stuff to sift through. It also costs you a ton of money. And so really you want to educate yourself so you have a better understanding. If you're representing yourself, you obviously need to educate yourself to be able to handle your case. But even if you have an attorney, you need to educate yourself so that you can leverage your attorney appropriately, save yourself a ton of attorney's fees, and be able to give them the pieces they need to actually do what they're there to do, which is practice law. They're not really there to tell you how to communicate, how to behave, and how to handle all these situations. They hope that you have enough understanding and self-awareness to know what the court wouldn't want you to do in those situations. And it gets very expensive when you're relying on your attorney for that education around those things. But most attorneys, I find, they didn't go to law school to handle that emotional aspect of it, right? And so a lot of us have therapists. I have a therapist. I've seen therapists at different points over the years. But honestly, what you need is something that fills that gap, that educates you from both what does the court want side and how am I behaving side, so that those two things can work together for you. Because if those two pieces are working counterproductively, you don't get any leverage in your case. And that's so, so important. And so this, again, is an example of why coaching services are so valuable, because it helps you pull all that together. It helps you know what you need to do. It helps you know, if you have an attorney, what they need from you. It helps you leverage the situation and increase your odds of success in court. Because again, most of the time when people fail, I find it's because of their own communication and their own behavior. It's not usually some procedural gotcha, which is what we think from watching all these law shows and all this legal stuff on TV, right? We think there's a hat that their attorney's going to pull a rabbit out and we've got some gotcha, but it doesn't really work that way in family court, because the judge isn't there to decide if someone's guilty or innocent. They're there to try and decide what's best for the family and the children specifically. And that's what guides most of their decision. And a lot of times I think we come at it trying to prove who's more guilty or more innocent, me or my ex-spouse. And that's not the lens through which your judge is analyzing this situation. And most of the time, even if your attorney does pull a procedural gotcha, it's usually just a delay. It's not usually enough of a, bomb that it totally changes the trajectory of your case. It usually is something that kind of will create a delay, buy you more time, kind of help you leverage a little bit more. But again, the biggest thing that you can do in this situation is make sure your communication, your behavior is on point, and that you're educating yourself around what the court wants from you so that you can understand where your leverage points are. Okay? That is the most important piece, whether you have an attorney or whether you don't. It all works together. So, this is an episode that Thomas and I had talked through a lot, and we had planned on recording. This was kind of in the hopper. And so I hope I've done a good job of presenting sort of the attorney side and the personal side for you. And I hope it's been helpful. If you are watching us on YouTube, don't forget to subscribe so you get notified as new episodes come out. And if you're listening to the podcast, don't forget to subscribe also so you get notified as new episodes come out. And thanks for joining me.
Thank you for listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira. For more information, visit www.divorceuniversityonline.com.